In this video, we cover tax practitioner responsibilities.
Okay, we are going to go over tax practitioner responsibilities. Circular 230 regs are the mandate for tax practitioners to exercise due diligence when representing taxpayers and filing tax returns. Due diligence is something that the IRS talks about a lot. The thing is that due diligence is never very clearly defined. They tell you that you have to try to create accurate tax returns to the best of your ability and try to get correct affirmations from the client and all this other stuff. But the actual term due diligence is not defined in the regs. Okay? However, there is one definition that is very clear, and that is that if you are an enrolled agent or a tax professional, whether you're enrolled or not enrolled, the IRS will presume that you have exercised due diligence if you rely on the work product of another tax practitioner. So that means that if your taxpayer brings in a tax return from a prior year, and there's like a $15,000 carryover on it, or $15,000 NOL on it, and you put it on the current year return, not thinking that it's wrong, and the taxpayer is later assessed penalties for that, you are probably not going to have a problem. Because the IRS does say that if you rely on the work product of another tax professional, assuming that it's legitimately looking on its face that it's fine, then you are presumed to have exercised due diligence. And that protects you from a preparer penalty, which is nice. That's why it's always good. If somebody brings in a prior year return, even if you didn't prepare it, you take a scan of that sucker and keep it in your files. Diligence as to accuracy. The reason why, see this section 10.22? This is the section in Circular 230 that this is under. It's like little chunks of rules. You don't need to know those section numbers, but I do have them in your handout so that you can, if you want to look it up and read the section because it's particularly confusing for whatever reason, that's the section that you look at. They're all in numerical order. You must exercise due diligence. This is obvious when preparing documents, determining the correctness of oral and written representations, and determining the correctness of oral and written representations made to clients related to any matter related to the IRS. Once again, you can rely on others. You can rely on the work product of another tax preparer. Okay? Now, this is what trips people up sometimes with EITC claims. You as a preparer, you have to determine the correctness of oral or written representations. Best practices, 10.33. Best practices, this is common sense stuff. Like, you got to communicate clearly with the client regarding the engagement. You know, most of us use engagement letters. You must establish the facts, determining which facts are relevant. Evaluate reasonableness of any assumptions. Evaluate reasonableness. The example that they give for this is, let's say you have a client come in and they're 23 years old and they want to claim two 14-year-old dependents. And you can't just take that on its face. You have to ask a question because that's not reasonable. A 23-year-old reasonably probably can't have two 14-year-old kids, right? I mean, I know that there's teen mothers out there, but that's kind of an extreme example, right? So in that case, the example that they give, the IRS, the example that they give is the tax preparer asked the client, how is it that you are the mother of these two children? And her response was, oh, my parents passed away, and I became the legal guardian of my two brothers who are minors. So that is a situation where you're going to put that information in your work papers, and then you proceed with the engagement because obviously you've asked pertinent questions, right? So that would be a legitimate engagement. Okay. Knowledge of the client's omission. This is the thing that Teresa asked about yesterday. Now, here is what you are required to do. CPAs and attorneys have different rules. I'm just talking about EAs now, okay? An attorney is not supposed to disclose, right? Every CPA has their own state rules that they have to go by, but all of those preparers, all of us are bound by Circular 230 rules, which is the knowledge of the client's omission, no matter what type of preparer you are. If you discover that your client has made an error or an omission, omission doesn't just mean error. Error means, I thought that this income was not taxable, but it is taxable. Okay? That's an omission. On any return document, affidavit, etc., you have to advise them of the error. You have to tell them, hey, this is a mistake that I found. The practitioner, on the other hand, is not responsible for fixing the non-compliance issue once they have notified the client of the issue. So you have to notify the client of the issue. You are not required to fix the issue. The tax professional is also not responsible for notifying the IRS of the non-compliance. These obligations, however, are not just limited to tax returns. So any type of advisory or tax consulting engagement will also trigger this requirement. If the person is your client and you find a mistake that might not even be related to the preparation of tax returns, let's say you're just doing their bookkeeping and you don't do their tax returns. If you discover that they have made a huge error at some point, or even a small error, you're supposed to tell them, and you're supposed to tell them the consequences of the error, but you are not responsible for correcting the error. Okay? That's knowledge of the client's omission. I can guarantee you 100% that this will be on the test. 100% you will see this. Conflicts of interest. So this is what I was talking about before. This is what you are required to do as an enrolled agent when you have clients that have a obvious conflict of interest. And the majority of the cases where this happens is going to be divorcees or clients who have filed jointly before with you and now they are filing separate returns, or they are divorced and there's still some stuff going on between the two of them. We have had a particular incident where we had two clients where they were married. We did file their joint returns. They divorced. The divorce was contentious. They still wanted us to be their things, which was fine. We had a written, you've got to do a written waiver, okay? The informed consent in writing. And they've asked, the IRS has asked this question before. If I inform my client by email, is that enough? It is not enough. They have to sign the waiver. They have to sign a waiver. So the fact that you just gave it to them in writing via email or whatever, that's not enough. You have to give them a waiver. You have to tell them what the facts are. You can probably download one of these off of the internet. That's consent. You have to have them sign it, and then you have to keep that paper in your files. Like I said, most of the time it's divorcees, and sometimes these situations are not easy, and you got to cut one of the clients loose. In our case, we had a joint filer. They went through a separation, and they were MFS, and they went through a divorce. The problem is that, yes, thank you. The problem is that at one point the taxpayer, the husband, was paying alimony to the wife. The husband comes in and he said, I paid my wife $15,000 in alimony last year. I want you to put it on the tax return. The wife comes in and she says, my husband paid me $6,000 in alimony last year. We do in the husband's return, so we know that the returns are not going to mesh, right? The wife wants to say, half of this alimony is actually child support, or it's not alimony. And the husband is putting 15, and she wants to put 6, which is a very common scenario. Apparently the IRS says 50% of the alimony returns they do, they don't mesh. They don't agree. At that point, I think my colleague ended up firing one of them. You just fire the one that doesn't pay as quickly or that's the more pain in the butt, right? That's what you do. But yeah, at that point we knew, we couldn't disclose that we knew because they're separate, right? So I can't go, well, your husband's saying that he paid you 15. I can't tell her that. Then I'm disclosing something that's on the husband's return. But I know that if I prepare these two returns, I know that one of them is wrong, right? I know that one of them is wrong because he can't be paying her $15,000 of alimony, and she can't be receiving $6,000 in alimony, right? He's the husband, he's paying her. I know that he's paying her. So somewhere along the line, one of them is lying, right? And I don't want that situation. Even though you have a waiver, at some point you might end up in a situation where you know you're going to be filing incorrect return because of this, and at that point it's best to kick the client loose. Say, I can't prepare this return, I know that there's a problem. Alright. The written consent, also called a waiver, must be retained for at least 36 months. They've asked about this before. You got to know that deadline, 36 months. From the date the representation ends. From the date the representation ends. It's not from the date of the tax return that you prepared for them, right? At a minimum, the consent needs to adequately describe the nature of the conflict and the parties the practitioner represents. IRS information requests. When the IRS requests information, the practitioner must comply and submit records promptly. IRS, when you go into audit work, the IRS will send you information requests. It's a formal information request. Most of the time what they're asking for is bank statements. They want to see the taxpayer's bank statements. Sometimes we don't have those. And that's mostly because the bank is going to charge the taxpayer, right? But if the IRS requests them, they don't charge the IRS, they just give it to them. And at that point, they're going to get them anyway, right? So we just say, we don't have them, but here's the bank, go ahead and get them. If the requested records are not in the practitioner's possession, he must promptly advise the requesting IRS officer and provide any information he has regarding who may have possession of the requested records. Okay, so this is actually in Circular 230. If the IRS calls me up about a client that I've fired, I'm not going to jump through a whole lot of hoops to help the IRS out. Do you understand what I'm saying? I don't feel like I should be calling anybody else to try to get information on somebody who's not my client anymore. That's not my job. But I will give them the information that I do have because I'm required to do so, okay? The practitioner must also make a reasonable inquiry of his client regarding the location of the requested records. Once again, if a client is fired, there was nothing reasonable about me calling them up and saying, where's your stuff? The IRS is knocking down my door. I'm not going to do that. But especially if the person is still your client, then yeah, you have to do the reasonable inquiry. The practitioner is not required to contact any third party who might be in the possession of the records. I've only had this happen once or twice, and it's when the taxpayer kind of dropped off the face of the earth. They knew they were going to lose. It's payroll tax cases where they didn't pay the payroll. The taxpayer knew they were going to lose. I knew they were going to lose. I'm not going to lie to them and say you're going to be able to get out of this. If it's like, if you didn't pay payroll tax, the IRS is going to chase you until you're in the ground. So you got to file bankruptcy or you got to do something. I can't correct this problem. Anyways, the IRS, I had a power of attorney for this guy. He was a nice guy. He just had a little bit of a drinking problem, and yeah, he just couldn't manage his business affairs anymore. And so this was like 5 years after the representation ended, and the IRS contacted me, the revenue agent that had been assigned to it. I mean, it was like right at the end of the collection statute, so they were going to, at the end of the 10-year collection statute, then that's it. They can't get the money anymore. And they were getting desperate to try to find this guy so they could get anything from him that they could. And it was like $32,000. It wasn't some small amount. And they called me and they asked if I could tell them where he was. And I said, here's the last address that I have for him, but that's it. I don't have anything else. So yeah, you've got to share that information with them. I don't ever like play hardball or anything like that, but if the person's gone, they're gone. And if they're not my client anymore, I'm not going to call them to find out where they're at. That's not me. All right. Return of client records, 10.28. This is really important, and we always follow this. 100%. The IRS is very serious about this, and tax practitioners, for some reason, want to do this. If a client comes to you and they bring their records to you, okay, and you prepare the tax return, but for some reason they don't like the result that you come up with, you have to give them back their original records. You cannot retain their original records. You got to give them back. And that's whether or not fees have been paid. You can't like keep their records hostage, right? You do not have to give them any of your work product, okay? And I have heard, like, we go rounds. When you have a client who's, you're firing for non-payment and they're trying to get like the QuickBooks file from you, you know, you're not required to give them your work product. You are required to give them their original records back and any records that they have paid for. And of course, if you complete the return, you've got to give them a copy of the return, but not if they haven't paid for it. The assumption is that you're not going to be filing unless you get a signature anyway, right? So you have to give them back their original records if they ask. You are allowed to make a copy of all of their records, and I usually recommend that. That's specifically allowed because you don't want this person to come back and try to sue you and say this and this and this. You, like, when that sort of thing happens, angry client, we always keep our work papers and put all the dates down, and the client came in on this day, blah, 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 blah. It's been a long time since I've had one deadbeat like that, but we did have one recently, like 2 years ago, and they came in screaming. The practitioner is not required to give the taxpayer any work product if he is withholding documents because of a fee dispute. Yeah, so have to give them back their originals. Copies of tax returns. Now, when you have a client, and it's RSC section 6107, when you have a client who comes in and you prepare their tax return, you got to give them a copy. You do not have to give them a paper copy. You can give them on any media. So electronic media, you can give them a PDF, you can give it the tax return on a CD. Usually I let people choose what they want. Older folks usually want a paper copy, and then younger people, they just want a PDF. They don't want the paper. But it can be in any media, and you will have satisfied your requirement. Preparers are required to also retain copies of the returns that they've prepared. So we print a PDF and then we keep it, right? That's what we do. Negotiation of taxpayer refund checks. The IRS asks this question every year on Part 3. You cannot ever negotiate or cash a taxpayer's refund check. You cannot have a portion of their refund going into your bank account. There are bank products, like that rapid refund type stuff, that you as a preparer can sign up for if you want to offer that to your client. But the whole idea behind that is that that stuff goes through a third party, not through you. Okay? So a practitioner cannot use this allocation form to allocate a portion of the refund into their own bank account, and they can't cash the check. The question that they've asked in the past is, you know, here in Sacramento we have like little check cashing places, and sometimes there's like a Cash One here like nearby. This is a check cashing place, and then there's also like a tax prep kiosk in there. They've asked questions before. If you have a tax prep place, but you also own the check cashing place, you cannot cash their check if they are your tax client. Does that make sense? They got to go somewhere else to cash that check. It's specifically prohibited. If you are the preparer on the return, you cannot negotiate their check, even if you're a check cashing place. All right? And we have those here. It seems like it might be weird, but yeah, there's one that's pretty close nearby. Okay, practitioner fees. The IRS prohibits practitioners from charging unconscionable fees. The IRS has not defined what qualifies as an unconscionable fee, but it's generally believed to refer to fees that courts would consider grossly disproportionate in relation to the services provided. So in the last class that I taught last year, one of the people in the class said, "What about $1,000 for a 1040A?" And I said, "I don't know. That seems pretty high to me, but who knows? Maybe the IRS would think that was okay." So grossly disproportionate in relation to the services provided. So probably you shouldn't be charging $5,000 for a 1040 easy, right? Okay. Contingent fees. Circular 230 has allowed, the current version of Circular 230, which has not been updated, does allow for contingent fees in a very narrow cases. You can charge contingent fees on an amended return and a couple of other things. That's what's in Circular 230 now, in the version that's current right now. However, in 2014, a contingent fee is a fee that's dependent on the refund amount. So you go, okay, I'll file your tax return and I will take 1/3 of your EITC claim. You cannot do that. You can charge them a flat fee, you can charge them an hourly fee, but you can't charge them a fee that's based on a percentage of the refund that you're going to get. You can't do that. And in 2014, a bunch of lawyers got together. It's always lawyers, right? A bunch of lawyers got together and they went to U.S. District Court and they argued that the IRS should not be regulating this because a taxpayer is allowed to do whatever they want with their money, right? If a tax professional wants to pay you 90% of his refund to get his refund back, then he is allowed to do that. He can do whatever he wants, right? That's their argument, right? The reason why the IRS has done this is because there's a big potential for abuse, right? There's a big potential for abuse. But apparently the courts agreed with the lawyers. And the landmark case is Ridgely. We just call it the Ridgely case because it's kind of like it pissed the IRS off so much. The IRS chose not to appeal this decision. Okay, so it's not a Supreme Court case, but the IRS let it sit. This part of Circular 230 prohibition on contingent fees is no longer in effect at this time. We do not know what's going to happen in the future. But as of right now, if I wanted to charge contingent fees, I would feel pretty comfortable doing so, okay? But the whole idea is that Circular 230 has not been updated and the IRS has not been very vocal about this loss. Now, the case was issued, the opinion in July 2014. Late in 2015, the IRS Advisory Council, I'm shocked by how many different councils there are, right? It's RPO, the Advisory Council, there's TIGDA, but it's IRS SAC, ERSAC, issued a report recommending that legislation be enacted to overturn the results in Loving and Ridgely, expressly affirming the Treasury Department's authority to regulate paid tax return preparers. They're so pissed off about this. They're sticking to their guns. But now they can't fight it in the courts anymore and they have to do legislation. So they're really, really busting Congress's, to try to get Congress to give them a legislation to allow them to do this, or really pushing it. However, at the time of the book's printing, the one that you have in front of you, no such legislation had been introduced. And you can go, and it's one of the footnotes in there, it's a quote where they said, the IRS is not backing down. They've lost two big cases in a row, and the IRS is not backing down. They said, we continue to believe that we should have the right to regulate tax professionals. Blah, 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 blah. But at this point, they've lost so many times that they got to stop fighting it through the courts. They got to try to get Congress to do it. And it might happen. Remember the thing that we talked about in part one, where an understatement of basis was not a material understatement for them to go back 6 years, and the IRS kept losing those cases, and finally they told Congress, fix this, and they did. Congress fixed it. They fixed it with the Surface Transportation Act, and now an understatement is grounds for the IRS to go back and open 6 years. But before, they kept losing and kept losing and kept losing. So in 2015, they got legislation to back their position, right? All right. Okay, advertising restrictions. Mail solicitations are allowed, and I always joke about this, as long as the solicitation is not uninvited. So if I mail a postcard to your house saying oh, I'm so happy that you're my client, I gotta make sure that it's not uninvited first. So do I call you up and ask you, is it okay for me to send a postcard to your house, client? I think it's weird. So you've got to make sure that the solicitation is not uninvited if it's via mail. I don't know very many tax practitioners that do mail solicitations. You can also solicit new business from a current or former clients or a client's family. So you can hit up your client's parents to try to get them to be your clients too. Practitioners may also send solicitations to other practitioners indicating their availability to provide professional services. This is how a lot of practitioners start out at the beginning when you first kind of get your thing. They don't have any clients of their own, right? So they'll do like bookkeeping and stuff for a CPA firm that's overwhelmed and they don't have enough hands or feet to be doing the tax returns they do have. So you go in and you can do independent contractor bookkeeping services a lot of times. And then they charge out your hours. You know what I mean? They pay you 20 and then they charge out the client 70. It's real common. Okay, a practitioner cannot use any form of advertising that contains false, deceptive, or coercive information, or that is in violation of IRS regulations. Practitioners are very restricted on the logos they can use. They can use the e-service provider logo and the IRS e-file logo. They are specifically prohibited from using official IRS insignia. And I have seen at least one practitioner, and he's going to get nailed for this. I've seen one practitioner online. I was looking for logos for the book, and he had taken the e-file logo and he put in like the Treasury Eagle in it, like he'd copied and pasted, and then he had it on his website. He's going to get in trouble for that. He should know better. Yeah, he was an EA. Maybe one of those that passed without actually taking the test, right? So he's probably an ex-IRS employee. I like to think so. Tax practitioners are specifically prohibited from using the official IRS insignia. Okay, so this is the official IRS insignia. You cannot take any part of either one of these and use it for anything, period. On your website, on your correspondence, nothing, nothing, nothing. These two are allowable. So this little square thing with it says authorized e-file provider, or the round one that's authorized IRS e-file. If you're a continuing education provider, then you can use the official logo for a continuing education provider. And the IRS will actually send that to you and say, this is what you can use. You cannot manipulate it in any way. Okay, so that's another IRS symbol that you can use, assuming that you qualify to use it. Okay, do you know that enrolled agents are not allowed to call themselves certified? You cannot call yourself a certified tax preparer. You can also not imply any type of employment relationship with the IRS. I do see this sometimes where they say, where enrolled agents will say certified or anything like that. You are allowed to say you're an enrolled agent. You're also allowed to shorten the name to say EA. And you can say that you're enrolled to represent taxpayers before the IRS, enrolled to practice before the IRS, and admitted to practice before the IRS. That's usually what people put on their cards, right? I'm admitted to practice before the IRS. A practitioner may solicit professional services using mail advertising. You got to keep it. You got to keep a copy for at least 36 months. Remember this? If you publish a fee schedule, like let's say you go online or you do a radio advertisement, which is another common one, and you say, I will do your 1040 for $50 if you come into my office and you're a new client. Let's say you get an avalanche of crazy people calling you and trying to get their $50 tax return. If you have published or advertised a fee schedule with a fee on there, you have to stick to the published fee schedule for at least 30 calendar days after it's published. So if you go out and you say, I'm going to charge you only $99 for your 1040, you have to charge people $99 for your 1040 for at least 30 calendar days after you release that advertisement. If you find that you don't want to do it anymore, it is tough noogies for you. You can get in trouble for that. Radio and television advertising, it's the same rules. If you do like a television ad or a commercial, you've got to keep that ad recording for at least 36 months from the date of the last transmission or use. Okay? Okay, other duties. This confuses a lot of tax professionals. You can be a notary and be an enrolled agent. You can be a notary and be a tax professional. It's very common. However, if you are a notary, you cannot engage in any notary activities related to any matter with the IRS. Okay? You can't notarize documents for the same client that you are representing in an audit. Okay? All right? Sometimes the IRS will ask you for notarized affidavits from one person or another to make sure, you know, if I said, that money's not income, that money was a loan from my sister and I put it in the bank, it was a loan, then you got to get, the IRS will usually say, you get an affidavit from the sister. You can't notarize the affidavit from the sister if you're the notary. So this is a very common scenario. They will ask for an affidavit from the person who are you claiming has the loan from, okay?
They don't require a notary acknowledgement on the affidavits anyway, as I recall, because you have that, you know, under
penalty of perjury.
Yeah. They have that clause above their signature.
Yeah.
So
I haven't had it a whole lot of times, but I have had a case where the loan was coming in from overseas. This was before FATCA and all that other stuff. The loan was coming in from overseas, and in that case, they wanted it notarized, and they requested that.
Foreign.
The foreign.
Yeah, right.
Yes.
That's more common.
Yeah.
Right, if it's coming in from overseas.
Yeah. And I do remember that one specifically.
Yeah.
But
I like affidavits. As soon as the question comes up, like a co-equity type of
yes,
arrangement,
co-equity.
even if they don't ask for it, I immediately get an affidavit from it's really son's house, and he takes on all the burdens of home ownership, and he does everything, he pays for it, etc. That seems to kind of close
the issue.
Yeah,
it helps
pretty quickly.
Yeah,
right.
It helps. Another thing, you cannot hire disbarred or suspended persons. Now this is really important. If you are an EA and you have another EA that works for you, or attorney or whatever, if they get disbarred, you have to fire them. You can't keep them on as a secretary or a tax preparer or a bookkeeper or anything like that. They cannot work for you, period. You cannot hire any disbarred or suspended persons. And if they are working for you, when they become disbarred or suspended, even if the suspension is temporary, sometimes the IRS will kind of slap a return preparer's hand for whatever reason, and they will suspend them for a year. If that happens, then they will, or a short period, you can't keep them on your staff. They can go out into the wild and actually still prepare tax returns, which is crazy, but you can't have them as an employee for your business. A tax practitioner must also not delay the prompt disposition of any matter before the IRS. They try to hit practitioners with this a lot, the delay tactics. But yeah, you're not supposed to delay IRS collections matters or anything like that. Okay, signature requirements. Every tax return that gets filed has a signature requirement, and we're not just talking about individual returns. Entities, payroll tax returns, they all have to be signed. Now, they have to be signed by the taxpayer or the taxpayer's representative, and they also have to be signed by the preparer, okay? If the preparer is the taxpayer themselves, obviously they're signing, they don't have to sign twice, but anytime you have an outside preparer, they are required by law to sign the tax return. They've got to include their PTIN, and they have to fill out the preparer area of the form. A preparer can sign original returns, amended returns, or extensions by rubber stamp, mechanical device, such as a signature pen, like one of those pens, or computer software. That's all a valid signature. The taxpayer, on the other hand, if it's a paper return, the IRS wants a wet signature. So they want an original signature, and I've had them returned for that as early as 2010. Taxpayers also must sign the return. They affirm that it's correct under penalties of perjury. A taxpayer, not the preparer, is legally responsible for the accuracy of every item on the return. If you do have a preparer that screws up royally, then the taxpayer can go after the preparer in civil court. But that's a civil case, and the IRS doesn't care about that. Okay? There's a possibility that you might use that as an excuse to get out of penalties too. Like, my preparer is the one that did this, and I was relying on his judgment, and that's gotten taxpayers out of penalties. But it will not get you out of the tax and interest that you're going to owe. You're dead in the water for that. The taxpayer is ultimately responsible for what's on the return. Okay, Unit 5. So there are practitioner standards for advice. The IRS recently expanded written advice to include email. How long has email been around? How long? I mean, I can remember having an email account
30 years.
at least.
30
Yeah, seriously, I had AOL, remember?
25
It goes on. We had email forever. And it just recently, the IRS expanded the definition of written advice to include email, almost anything in writing. And amazingly enough, they actually included texts. So they're like, we're going to get with the program, we're also going to include text. So you can't send your client texts that teach them how to evade tax, I guess. Any type of electronic communication on any federal tax matter is also going to be listed under this practitioner standards thing, umbrella. Okay. You must base your written advice on reasonable factual and legal assumptions. Consider all relevant facts. Use reasonable efforts to identify and ascertain the facts relevant to the written advice. You cannot rely on representation statements and findings given to you by the taxpayer. Now, this is important because a lot of what we do is we rely on the taxpayers, what they tell us, right? Sometimes the taxpayer will come into you and they're just giving you a QuickBooks file and you don't actually see like the 1099s and all of the charitable gifts and everything else. You see maybe the accounting or the bookkeeping, or maybe you ask for one or two things, but you don't see all of their receipts. You don't see the basis for all of the deductions. And you're not an auditor, you're a tax professional, right? But the thing is that this practitioner standards says if you feel, or if a reasonable person would look at that information that the taxpayer gave you and think that it was unreasonable, then you could be held liable, even if you're using that to prepare the tax return and the taxpayer has told you that information, okay? This is especially true with EITC claims. You gotta tread carefully. You must relate applicable law and authority to the facts. That is also part of your job. Now the IRS is really strict about this. When you issue written advice, or even oral advice, a practitioner cannot take into consideration the chances that a tax return may or may not be audited. So you cannot give a taxpayer advice based on like the audit lottery. Do you understand what I'm saying? And you never make sure, you gotta make sure that you don't give that, if you give it to a client an email or any kind of written advice, that it's never phrased that way. I will tell clients that something is an audit trigger, like if they come in and they want to put like $73,000 of mileage on their 2106 as employee business expense. I'll go, no, you can't do that. I don't want 100,000 or 50,000 or even 30,000 of miscellaneous itemized deductions from your job that exceeds your wages. That's ridiculous. But when you give written advice or oral advice to taxpayers, you can't say, I think we could get away with this because I don't think you're going to get audited. This is probably under the threshold where you're going to get caught. That's not allowable. Okay? There are standards for tax returns documents. You cannot willfully sign a return. So you can't sign a return that you willfully know lacks a reasonable basis. Okay? That has an unreasonable position is a willful attempt by the practitioner, not the taxpayer, a willful attempt by the practitioner to understate liability. And in determining potential penalties, the IRS will take into account a pattern of conduct. Tax preparers, when they get in trouble, sometimes you'll just have one bad one. If the IRS comes in and starts auditing your tax cases, and they start opening up your files in your life, they're looking for a pattern of conduct. They're looking to see, do they have 90% EITC claims that are looking real shady? Do they have a whole bunch of Schedule C taxpayers that don't have any reasonable basis for the income that they're claiming on there? That sort of thing. They also do this a lot when it's tax shelter promoters. They kind of go after them. Okay, you cannot, of course, advise a client to submit a document that is frivolous. Frivolous, oh boy. Frivolous is when you have a tax protester, okay? That you try to think what's a frivolous? Frivolous is when you have a tax protester. I every now and then I get one in my office. The problem is that they look like normal people, right? But they're crazy. And This is a person that does like the whole thing where the U.S. Constitution doesn't say that I have to do the tax, and George Washington didn't pay income tax, and they came up with all these cockamamie arguments, and that's a frivolous argument. I don't want those people as clients, and you cannot sign a frivolous return. I am going to give you an example of one where the tax professional did it unknowingly. And there are two standards for this. This is very important. You have a more likely than not position. More likely than not means more than 50% chance that the tax position that you have will be sustained. And then you can also do reasonable basis as long as you have adequate disclosure. Okay? We're going to talk about that. Okay. An unreasonable position is a position that has no reasonable basis. You pulled this out of the air and you put this on the tax return, and there's no way that this is ever going to fly. Okay? However, this is going to be a penalty that attaches to you as the preparer. There's plenty of penalties that attach to the taxpayer, but this is going to attach to you. No penalty is going to be imposed if it's shown that there's reasonable cause for the understatement and the preparer acted in good faith. So there's some times where you're going to get away with it, and we can talk about that too. Okay, the more likely than not is there's a greater than 50% chance that the tax treatment will be upheld if the IRS challenges it. Okay? If the preparer is unsure that they're going to meet this standard, they can generally avoid penalties by disclosing the position. And then a reasonable basis is minimum standard, and when you have a reasonable basis, you have to disclose it on the return. There's a special form for that, and tax preparers, we call that the poor man's PLR. The poor man's PLR. So you attach to the disclosure statement, there's an actual form number for that. And then what ends up happening is when you have a tax return that has a disclosure statement, it gets flagged. So those tax returns get looked at by a human, not just by a thing. I think they get forwarded to the IRS Office of Chief Counsel, and a lawyer there takes a look at it. I've used them a couple of times when I wasn't certain, and in that case, I've always prevailed. I've never had an issue, but in that case, you can eliminate the risk for yourself and for your client because you're telling the IRS, you make the decision. I'm going to give you the facts, and then you tell me if this is going to fly or not. Okay? An unreasonable position is an undisclosed position with no substantial authority, and that's where you get in trouble. Okay? Now, the example that I give for this, the example that I like to give for this is this, because sometimes you're breaking new ground, right? Sometimes you're breaking new ground as a tax professional, and you don't know if what you're doing is going to be allowed. The example that I give is the Chesty Love case. Chesty Love. You can actually look this up, and it's a real tax case. It didn't happen too long ago. I think it was like 1994. The Chesty Love case is a tax court case that went to tax court, and this was an exotic dancer, stripper. Chesty Love was an exotic dancer who filed on the Schedule C. Okay? She had a tax professional, and she deducted her breast implants. And she was a Schedule C filer.
I remember.
You remember this, yeah? She's a Schedule C filer. Now, cosmetic surgery for enhancement, like breast implants, unless you have breast cancer and you've removed your breast because of breast cancer, that would be a medical expense. You cannot deduct your breast implants as a business expense, right? It's ridiculous, right? It seems ridiculous. Well, Chesty Love went to the tax court, and it was pro se. You know, I'm assuming that her accountant got to the appeals level and said, I think maybe you should push this. Yeah. She did. She got to the tax court, to the U.S. tax court, and it was pro se. And she argued, she said, I was making, and this is true, she actually had like backup. I was making $700 a week as an exotic dancer when I had my normal boobs, breasts. I put the breast implants in, and they were crazy. They were like F something. G.
I mean, they came
out here. She went on Jerry Springer, so you could actually see
it
her.
was heavy
and uncomfortable. She said, if I could take them out every day and put them on a shelf at the end of the night, I would do so. But her income went up like where she made was a gazillion dollars. She made $700 a week, and then when she did the huge breast implants, she started making $70,000 a week. So, as a stripper, exotic dancer, she did all these appearances. She was on Sally Jessy Raphael and all this other stuff. So she was famous, and they were not like anything normal looking at all. It looked like she had like 2 pumpkins on her chest.
Yeah.
So
it was grotesque.
Grotesque. And that was what she argued. Yeah. So there was a week, and that's part of the reason why she ran her case. Yeah. That's part of the reason why she won her case.
She argued it was not
cosmetic.
Cosmetic. It was not. In fact, you know, it's uncomfortable. It's terrible, etc.
Yeah.
But this is what I need to do to make
money. And she said
it's a direct correlation between the income and her
breast implants. Right. And what she did is she said, this should not be treated as cosmetic surgery. I treat them as a prop for my stage show. And the IRS did not think they were going to lose this case. And the judge smacked them down.
Yeah, the judge used the word grotesque.
Grotesque, he actually did.
Yeah. He used that word.
It's a very interesting case.
To go that far to make something grotesque, this is not, you know, cosmetic in any sense of the imagination, but rather a grotesque kind of blah blah blah. And I was floored that the judge said that, actually used that word. And so that's what killed the IRS, is that you know, it at all levels, perception, you cannot say that this is cosmetic at any level.
The part of it also was that the IRS was arguing that that cosmetic surgery is a personal expense. You do that to improve your appearance. But the taxpayer themselves said, I did not do this to improve my appearance. I've become like, I don't like the way that I look this way, but obviously I went from making $700 a week to $70,000 a week. So what would you do in my position? She's like, I wish I could take them out at the end of every night, but it's medically impossible. But she won. Yeah, she won. So the reason why I brought up this case is because, let's say you are the tax professional in the Chesty Love case. No one had ever won to deduct their breast implants. This was the first time anybody got to deduct breast implants as a prop for their business. No one had ever done that. So, in that case, what are you arguing? You're arguing reasonable basis, because there's nothing else for you to go on. And probably the tax preparer disclosed the position, it got flagged, and the IRS thought that they could win this, and so they fought it and they lost. Now that this case is out there, the Chesty Love case is out there, now we have a more likely than not. Because somebody else already broke this ground. They went in with a reasonable basis, with a reasonable argument, they won, and now we have a more likely than not, where we don't even have to disclose. Because the IRS has already lost this in court and the courts agreed, right? So there is, I would say, that if I get an equivalent thing, and I have a lady come in who is an exotic dancer, and she has huge breast implants, and she wants to deduct them, then I think that there's probably a greater than 50% likelihood that I'm going to get, that we are going to get that upheld, right? So it went from reasonable basis to more likely than not, all right? Does that make sense? Okay. You can rely on information from clients. You are not required to verify all the information, okay? So you're not an auditor. However, you should not ignore the implications of the information, and you should also make reasonable inquiries if the information appears to be incorrect or incomplete, okay? If you are a tax practitioner, you know, you have to kind of use your gut sometimes when it comes to this sort of thing. You know, if the taxpayer seems shifty,
if it walks like a duck,
quacks like a duck. You know, the example that I give is, if somebody comes in and they've got a little Schedule C business, and they have, because I've actually had this happen, they got a little Schedule C business and they're claiming like $15,000 of income with their kids. They're like in EITC territory, right? But if they're driving up in a brand new Hemi that's like a $60,000 truck, I'm a little bit concerned. You know, I go like, well, how are you affording this truck and this house and all of this other stuff? You went on a trip to Hawaii? You made $15,000? You know, you know, that means that you've got like unreported cash, right? There's something else going on, right? Unless they won the lottery, even then they'd have to claim it, right? Okay, disclosure statements. The disclosure statement is the one I was talking about, the 8275. This is where you can formally disclose a position on a tax return. You attach it to the return. It's a formal form. You disclose the position, right? And you can use it to avoid accuracy-related penalties. There's a chance that if you give the taxpayer, the IRS, the position that you've given them, there's a chance that the IRS is going to disallow, right? But when you do this, unless it's a frivolous argument, you're not going to get dinged. The IRS just tell us, and like I said, I've used this on more than one occasion. I've prevailed. Form 8275 cannot be used to avoid the position of the accuracy-related penalty attributable to certain types of misconduct, including negligence, disregard of regulations, and any substantial understatement of income tax on a tax shelter item. The time that I used this form, just so you guys can kind of get an idea of how it works in the real life, I had a client where the kid had been pulled from the home of the parents because the parents, whatever they were doing. The kid had been pulled from the home of the parents, and the mother had claimed the kid to get EITC. The kid had been living with like grandma and then aunt and then cousin and then all, you know, like in different homes. The grandmother basically had the kid, so more than half the year. The mother had already claimed the kid, right? And the grandmother said, is there a way that I can claim the kid? Because the mother's not really involved at all. And I actually attached the disclosure statement and we filed on paper because we got an e-file reject when I tried to do it that way. I sent it on paper and I also sent a copy of the thing where they took the kid, the word of the state type paperwork. I don't know what it's called. And the taxpayer got it. I got the EITC for the grandmother. Made me feel a lot more comfortable about putting that kid on the return and getting EITC for the grandmother. Definitely. Covered opinions. Covered opinions. When you hear covered opinions, the IRS keeps going back and forth. They keep naming things different. A covered opinion is a tax shelter opinion. A tax shelter. I don't want you to think that tax shelters are all bad. The most common legal type of tax shelter is a 401k. A 401k is a tax shelter because you're sheltering the income that you put into a 401k from tax. But there's a lot of like tax shelter schemes that are illegal. I looked up one the other day because I was trying to get an example of what an illegal tax shelter would be. And it was a situation where, I don't know if you guys know this, but a lot of wealthy men, especially, when they get up and they start to make a lot of money, they like to do stuff with race horses, like thoroughbreds. They do stuff with horses. I'm serious. Oh, why are you laughing?
I want to do that too.
You do? Oh.
We have
no,
horses, so
yeah, so they like to invest in race horses, racing horses and thoroughbreds and stuff like that. There's special rules that go along with that and everything. They're allowed to have a loss for a longer period. I think it's seven out of 10, yeah. 7 tiers. So you know how most businesses, it's 3 out of the last 5. You got to show a profit. But with race horses, you can show a loss for 7 years. It's kind of a unique thing. Anyway, so in one of the cases that they had where they actually went after the tax shelter promoter, there was a situation where they created like a trust to buy fancy race horses. And this was not a small amount of money. We're talking like $1.5 million. And they purchased the race horses using loans, and then they were breeding them. And the guy was kind of just liked horses and wanted to do this as a hobby, like for fun. But they're treating it like a business, and it's like losses and losses and losses and losses and losses year after year, like funneling through because of this racehorse stuff. And he's claiming it's a racehorse business, and of course it's like a doctor. So, anesthesiologist, I think it was. And the IRS came in and said, you've put all of this activity, this racehorse activity, into a trust, and you're claiming all these losses from this activity, this is a tax shelter, it's an illegal tax shelter, this is a hobby, guy. You're not breeding racehorses, you just like horses. And he lost. He got in trouble for that. So that is the type of activity that you see when you see like unethical tax shelter stuff. They're doing something like racing, race cars, and they're trying to pass it off as a business, but it's really just like some rich guy's fun thing that he wants to do. Does that make sense?
And wants to offset his
ordinary income, right? Because if he's making like $900,000 from being an anesthesiologist or a plastic surgeon, they like to do this kind of stuff because then they get into these like hobbies that are for rich people. And then they have like these huge losses coming through. I'm going to take a $500,000 loss for my racehorsing activity. They get to shelter all of this from tax, but it's a hobby. It's not a business. Yeah, so that's this type of thing. If you look up like illegal tax shelters or tax shelter stuff, it's always something like this. The rules that have led, okay, so the IRS changed this thing, and I actually saw Karen Hawkins. I actually really liked her. I felt like what she was doing was the right thing. She had her heart in the right place, but she lost, and I think it must have been really demoralizing for her. But anyway, when I saw Karen Hawkins speak, and she talked about this, they hated this. You know the email at the bottom of every tax practitioner's email that says, according to IRS Circular 230, unless otherwise indicated, any tax advice contained in this email is not intended to, written, or be used and cannot be used for the avoidance of penalties that may be imposed by any relevant authority. Apparently, Office of Professional Responsibility got their panties in a bunch about this. They didn't like these. They didn't like this blanket boilerplate disclaimer that all of tax professionals and CPAs were using on their emails, and they felt like it was kind of pointing a finger at them. So, the Office of Professional Responsibility, when I saw it, they go, the deletion of the covered opinion requirements, they deleted the covered opinion requirements. The IRS requests nicely that you remove, and I removed the disclaimer from my email. It's in my old email, so when I search the old emails, I see it down there. But they request that the practitioners remove the disclaimers or that they state that are required by the IRS, OPR, or Circular 230. They don't like that. Now, they say that they request it, but OPR came out and said, we will send you a cease and desist letter. We will send you a cease and desist letter, like a legal threat, if you continue to use it. So we ask nicely that you remove it. If you do not remove it, we're going to send a cease and desist letter. They say that it's misleading. They don't want the finger to be pointed at them for this. Okay. Now there are reporting requirements for tax shelter activities. Any taxpayer who is involved in tax shelter activities, they have to report the tax shelter activity on their tax return. They have to report it. They have to report the tax shelter number, and they have to report the activity, okay? There is a special statement for this. It's called a reportable transaction. When you see reportable transaction, tax shelter, covered opinion, that's all tax shelters, okay? If you do not include this statement along with your tax return, even if your tax return is otherwise perfect and you have not failed to disclose any income or anything else, the IRS can smack you down for any understatement of tax and any additional penalty equal to 30% of the understatement. They will find a way to stick you with this penalty. They hate this. They hate it when people try to get under their radar. Okay. If you are a tax professional that employs other tax professionals, okay? If you are a tax preparer and you have other tax preparers working for you, there are specific rules in Circular 230 that have to do with firm compliance. The IRS basically has stated, if you are managing a firm and you end up having a rogue preparer, like a preparer that is filing fraudulent returns, you are going to be partially responsible for this, okay? whoever is overseeing the firm's practice, that's going to be the managing partner. If it's a partnership, it's going to be the two partners, whatever. But the buck basically stops with you. The IRS is saying that that person is going to be ultimately responsible for making sure that there are adequate procedures in place for every member, associate, or employee to comply with the requirements in Circular 230. If the IRS finds that the owner of the tax preparation firm has not taken reasonable steps to make sure that they are compliant with Circular 230, they can face disciplinary action. So you guys can understand this, I have my firm, Christie's EA tax practice. I have 3 preparers under me, okay? Jim, Sue, and Tim. Tim is filing fraudulent EITC claims using my software. I'm kind of like just letting them do what they want, right? If the IRS comes in, Tim is going to get it, but I'm going to get it too. All right? They will attach penalties to me if they can't get them from Tim. They'll probably just bar Tim, and they might go after him for criminal penalties, but they're sure as heck going to get me some disciplinary action and also some civil penalties attached to me too.
Subscribe to PassKey Online for more great content about the Enrolled Agent exam.